This case is not about a witness coming into court and identifying the defendant as the one who robbed him, or shot him, or robbed him, or beat him, or shot him, or shot him. That's not what this case is about. It's not about a witness coming in and making an in-court identification and saying that's the person who did this crime. This case is much bigger than that. This case is about how all the evidence fits together as a connected series of events, a connected series of evidence that interlock together that prove the defendant is guilty of a conspiracy. This case, as I said in my opening statement, as I said in my closing argument, was a 6-month conspiracy where the defendant and his co-confederates were robbing people, beating people, shooting people in their own homes, in their own cars, in their own businesses, all because they wanted the things that those people had. They wanted to take something that did not belong to them. And so when they wear guns, when they wear masks, and they wear surgical gloves, and they conceal their identity from their victims, it's no wonder that those little old ladies who are in their own homes, on their own side, in northwest Detroit, can't come to court and say, that's the person who robbed me. It's no wonder, because that's one of the reasons the defendant decided to prey on old people, was because they have money, they're vulnerable, and you know what? They're probably not going to be able to identify me, especially if I conceal my identity. And you heard the stewards testify about how someone's identity was concealed. And yes, this case is not a case where Judge Berg comes in, or his wife comes in, or anyone else comes in on that night and says, that's the defendant who I saw rob and shoot me. But you know what? There's other evidence that I'm going to tell you that corroborates the testimony of Williams and Adams that places them at the scene of the crime. So when we talk about identification being part of the evidence, it's not just a witness coming in and saying, that's the man who robbed me. Judge Berg, Ms. Sevier, the stewards, the owners from the jewelry store, they all had varying different degrees of identification along with the defendant, along with Mr. Williams and Mr. Adams. Judge Berg said, you know, I can't come in and say 100% that this is the person that robbed me, but now that I'm looking at him, he has distinctive eyes. Think about that for a moment. Judge Berg was 2 feet away from the person who shot him and tried to rob him and his family. Looked right in his eyes, as close as I am to you, and says, I can't see 100%, but that man has distinctive eyes. The same eyes that I saw that night on March 5th of last year. The same person who shot me and tried to rob my family. Did not eat positively, but said positive. Those are distinctive eyes. There's an old saying that eyes are the window of the soul, ladies and gentlemen. When you look into the soul of someone who's trying to rob your family and who shoots you on the porch of your own home, I would submit that's not something that one would forget. So when Judge Berg comes in and says, distinctive eyes, I submit to you that's additional proof that you can use to corroborate what Mr. Williams and Mr. Adams says. It doesn't stop there. Ms. Sevier looked at the lineup with Mr. Smith. Now remember, she said, I didn't see his face. I saw him as he's running away. And Mr. Smith told us today that he has a different height, different build. He's taller than the other individuals. Mrs. Sevier says, I saw him as he was running away. And you know what? Number 4, Kevin Smith, looks most like the build of the guy I saw running toward the vehicle after my husband was shot, after I come out of my house, and that night. So when you talk about identification, what I'm suggesting to you is that you can use these pieces of the puzzle to connect the dots as it relates to Mr. Williams and Mr. Williams and Mr. Adams' testimony. The judge's eyes, Ms. Sevier's build as he's running away. Simon Stewart from Hilldale said, number 4, Kevin Smith looks like the guy who held me at gunpoint. That's what she says when she looked at the photograph. So again, when Mr. McWilliams says there's no identification, what I'm suggesting to you is that these individual identifications corroborate what Williams says and what Adams says. Yes, they don't come in and say 100%, that's the person who was standing in my bedroom, or that's the person who shot me, but it corroborates what they said and places the defendant at the scene of the crime. We have the jewelry store owner and his brother. They both say that's him. They're 90 to 100% sure as they're looking. And it was funny on cross-examination, the brother comes in and says, I wasn't sure until I saw him right there. Now I know beyond any doubt that's the guy who's in the jewelry store. And we know it's him because he admitted it. He admitted that he's the actual one in the jewelry store. So identification in the jewelry store is really a moot point. Mr. Williams and Mr. Adams indicated that they committed several armed robberies together. And they did that together. And when they get back to the car, what did Adams say he said? He said, dude thought I was playing. Dude, Judge Burke, thought I was playing. And that's why he shot. Is that something that Mr. Adams would just make up? Is that a statement that he would not attribute to the person who actually shot the individual? I submit not. This is part of credibility, ladies and gentlemen. When you decide credibility of the witness, you look at how their credibility fits with other pieces of the evidence. How their credibility fits with the eyes of the defendant, with the bill of the defendant, the identification of the defendant by the people in the jewelry store, the identification of the defendant by Miss Stewart as the one that looks like the person who held a gun to her as she's sitting in her room doing her own knitting. Another thing that you need to consider when you judge credibility is that how the witnesses testify. Did they answer the questions? They answer the questions, they appear to be truthful. Or did they argue with the lawyers and try to evade the questions? The only person who tried to evade questions or refused to answer questions is the defendant. You heard his testimony, and you heard how he tried to evade questions and how he tried not to answer questions, and how he just not refused to answer some questions. Compare that credibility to the credibility of Mr. Adams and Mr. Williams, who came in and took a full account of what they did. Robbing people, pointing guns at people, taking property that did not belong to them, owning up to their responsibilities. Yes, they may have told the police they weren't involved, but when they told the police they were involved, they told them everything. They didn't lie like the defendant did. The jewelry store. Again, the defendant's testimony, when you judge his credibility, he says there was no plan to rob. That's ridiculous. That's ridiculous. Because the evidence is going to show, and if you look at the evidence, it's going to show that, in fact, there was a plan to rob. Look at this text message that the defendant sent the day before the robbery takes place. He says he told you that he was staying with his friend in Warren, and he wasn't part of the plan. This is a text message that he sends to Mr. Russell, who he says wasn't even there, the night before the shooting, and he says, are those clothes still at your house? I'm going to spend the night at your house. The night before they drive out to Roseville to the robbery, when he says he's in Warren with his friend, he spent the night at Russell's house, according to his text messages. Again, when he says there was no plan, he lied, because he has to lie. Because if he says there was a plan, that's the conspiracy, just an agreement to do a crime. Here is more evidence, ladies and gentlemen, of him planning ahead to do a robbery. I'm going to spend the night at your house, Mr. Russell. He told you Russell wasn't even there. It was just him and somebody else he refused to name. This text message say otherwise. He says Williams wasn't at the robbery. Well, you heard, and I talked about this before, you heard the owner come in and say that someone, when I was bleeding, I came out and he said it was an African-American man who identified himself, a young man, said, I'm going to go off and get him. How would you know that? How would Williams know that? Because the defendant didn't know that. The defendant says he told Williams about the robbery. He wasn't there. But how would he, the defendant, know that he already left? He wouldn't. He's lying to you. Also, he refused to answer questions. The defendant refused to answer questions directly put to him when I asked him questions. Compare that to the testimony of Mr. Williams. Okay? Now, this is an important point. Mr. Williams testified that he, the defendant, used his .45. Used a .45 caliber to shoot Judge Byrd on his porch. He asked to borrow the gun. And when you think about that, it kind of sounds odd initially when you think about borrowing guns, but we know that they did share guns because we know that, according to the defendant, on Fowl Street, which he wasn't part of that robbery, they had his gun with the laser. And they admit that. But in this particular case, Mr. Williams says that he had a .45 and he gave it to the defendant. Now, it's important because that gun was never recovered. We admit that. We told you that in the opening statement. But remember when the search warrants were executed, all those items we went through, and you can look at them if you want, and the photographs, there was a .45 ammunition recovered from Williams' house. .45 caliber ammunition recovered from his house. Why do you need a .45 caliber ammunition if you don't have a .45 caliber gun? Just like the .380 that was recovered from the defendant's house. Didn't fit the .40, didn't fit the .9, but he still had it. So Williams had .45 caliber ammunition in May when he's arrested. Doesn't have a gun anymore. You know why? Because the defendant sold it. He told you, Mr. Williams told you that he sold the gun and got a Ruger, a 9mm Ruger, and you heard the defendant, and you heard the jail call. Can you play that? The day after the shooting on March 6th, this is when the defendant calls his friend, Mr. Swindle.
I already agreed on one thing.
Sounds pretty.
Said what? Said what?
I said, that thing, that it sounded pretty.
Yeah, well, that big 9 Ruger. That big 9 Ruger.
That bitch sounded so pretty. That bitch sounded like that bitch was boiled up on the greasy tip on the
Yeah, I have to take the thing out of this play with the cock back so you can shit, you know what I'm saying? Yeah.
But you got that bitch on your lap, huh?
Hell yeah.
You was a goofball. Nigga, sit your ass down. All right, man, I'm gonna holler at you.
Mr. Smith says, I never had a Ruger, or maybe I did years ago. I didn't have a Ruger in this time period. But Williams tells us that the day that after the shooting takes place, sometime after, he trades the gun. Here, for a Ruger 9mm, here the day after the shooting, he calls his friend playing with his new toy, racking it, showing it off, talking about it, saying it's a Ruger. And he on the stand, he said, I don't have a Ruger. I don't know, maybe I misspoke. Does it sound like he's misspeaking to you? It sounds like he's lying to you. Compare the way that Mr. Williams testified to the way Mr. Smith testified. Mr. Williams told you what he did. He said he stuck a gun in the face of a special needs child. He told you he burst into a woman in the bathroom and stole the jewelry off her ring, her necklace, snatched it and ran out. He told you he was involved in tying up and robbing Mr. Rooser. He told you things that probably curled your spine like they did mine, because those are things that are awful. Awful things that he did, but he came in and owned them. He took ownership of what he did and told you what he did. In addition to what he talked about the walk-in robberies, he told you about 4 other robberies they participated in. I'm not going to go through them, but he talked about 4 other robberies, and we proved those robberies occurred just like he said they did. And the physical evidence ties him and the defendant to those scenes. Asbury Park, Ward, the jewelry store, and the dollar store. Because Mr. Williams told us about that. So he took ownership of that. But Mr. McWilliams says that the whole idea is to blame this on Mr. Smith. That's what they wanted. But he didn't blame him on Faust, did he? He never said the defendant was involved in Faust. He said, me and 2 other guys did Faust. The defendant wasn't there. So if this is about blame the defendant, why isn't he blaming about Faust? I mean, it'd just be easy to come in and say, he did all of them, wouldn't it? But he didn't. He said, no, that's mine, not his. Compare that with the demeanor of the defendant versus the demeanor of Mr. Williams. You saw the way he testified, how emotional it was when he testified, and you heard the officers testify about how upset he was when he's describing the events that he did, and how he testified about this, and how he testified about shooting something. But he told you about that. The defendant lied. And the defendant told you, the defendant lied under oath. He told you he lied under oath. He stood right here in this chair and said, I lied under oath. I committed perjury. Do you want you to believe him? Compare that to the way that Mr. Williams testified, the way Mr. Adams testified. There is no comparison between the two. You know, a lot of the things that we talk about, in this, in the court system, come from our ancestors. The court system that we have comes from Anglo-Saxon traditions, about a judge wearing a robe, about the judge being elevated, about people taking the oath, about having jurors of your peers come in and decide cases, having lawyers trained in the law. Thankfully, we don't have to wear wigs, although I could probably use one. We don't have to wear those. But there are certain things that are left over. The oath is one of them. The oath, when you raise your right hand and swear to tell the truth. Why do we raise our right hand? Why do we expose our palm to the world? Because one of the traditions that they used to have, way back, is if you were convicted of perjury, they would brand you with a P. Right in your hand. So that if you raise your hand, you can never testify again. It wouldn't matter if you were a victim of a crime, someone took some property from you, you couldn't go to court and testify. Because you raise your hand, you say the P, I'm sorry witness, you can't testify, you're convicted of perjury. That's how serious perjury was treated by our ancestors. But we don't brand people, but we take perjury seriously. And the defendant lied to you. under oath. You committed perjury. So when you decide who to believe, I submit to you Williams and Adams' testimony is corroborated by the physical evidence and the evidence of other witnesses in this case. He told you I never lied. Remember that? Last thing he said. I never lied. I don't think he ever tells the truth. Mr. Williams makes a statement that this case is all predicated on Mr. Williams and Mr. Adams, and they got a deal and they have to testify. And I told you earlier, you have to consider that testimony very carefully, because that is a condition that you should think about. You should think about the fact they got a deal to testify, right? So you should be very careful about how you evaluate the testimony. I ask you to do that. I ask you to look at their testimony carefully. But when you look at their testimony carefully, you're going to see that, but for their testimony, Mr. Smith would still be on the street, robbing old people, shooting people, and pistol whipping people. And you'll see that not only was the robbery part of the conspiracy, but also the assault was part of the conspiracy too. Because I showed you earlier, there were 5 instances where the defendant used violence when someone resisted. The dollar store, the jewelry store, Faust, Asbury Park, and Oak Drive used violence. So violence is part of the conspiracy. So you know what, ladies and gentlemen, for purposes of this case, it doesn't matter if the defendant was the one who pulled that trigger on March 5th, 2015 on Oak Drive. It doesn't matter. Because the violence, the assault, is part of the agreement. It's part of the plan. If they don't cooperate, they get hurt. So it doesn't matter if you pull the trigger. It doesn't matter if Williams is on the step with the judge or the defendant. It just doesn't matter. But you know what? The evidence suggests that it was him. That's what Williams told us. That's what Adams told us. That's what the physical evidence of all the other corroborations tell us. So when you weigh that testimony, weigh it very carefully. And I'm not going to apologize for making deals with these individuals to stop the cycle of violence in the city of Detroit. To stop little old ladies and old men from being preyed upon by that man. So I don't apologize. But for the testimony of Williams and Adams, he'd still be out. He'd have gotten away with it. There is a presumption of innocence. There is a burden of proof. It's your job to decide whether I met my burden of proof, whether I proved beyond a reasonable doubt the elements of the crime. I submit to you I have. And I submit to you that when you go back and make your decision, you'll decide in your verdict whether I've proved beyond a reasonable doubt or I haven't, whether he's guilty or he's not, and that will be your verdict. And your verdict will be justice, whether it's guilty or not guilty. Whatever you decide today, whatever you decide, is justice. Because that's the way our system works. That's the faith that we put in the system. So whatever your verdict is, it's going to be justice. But for those individuals who are robbing their own homes, or pistol whipped, or shot, things are taken from them, I submit to you there's only one verdict, and that is that he's guilty of conspiracy to commit robberies, guilty of assault with intent to murder, guilty of armed robbery, felon in possession of a firearm, felon firearm. On behalf of all the victims, ladies and gentlemen, I'm asking you for justice.
Members of the jury, the evidence and the arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies in this case. Remember that you've taken an oath to return a true and a just verdict, based only on the evidence and my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of this case are. This is your job, and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. Now, it's my duty to instruct you on the law, and you must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law that you are to follow. You shouldn't pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are. You then apply those facts to the law as I give it to you, and in that way decide the case. As I told you at the beginning of the trial, even during our jury selection process, a person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that the defendant is guilty. Now, every crime is made up of parts called elements, and the prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. So what is a reasonable doubt? A reasonable doubt is a fair, honest doubt, growing out of the evidence or the lack of evidence. It's not a possible doubt. It's not an imaginary doubt, but it's a doubt that's based on reason and common sense. A reasonable doubt is just that. A doubt that's reasonable after a careful and considered examination of the facts and circumstances in the case. Now, when you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in the case. Therefore, it's important for you to understand what is evidence and what isn't evidence. Evidence in this case took three different forms. One form was the answers that came from the witness stand, not the questions of the lawyers, but the answers that came from the witness stand, the physical exhibits that were received into evidence, and the stipulations that I told you about during the course of the trial. Now, many things are not evidence, and you must be careful not to consider them as such. I'll now describe some of the things that are not evidence. The fact that Mr. Smith is charged with multiple crimes and is on trial is not evidence against him. The lawyer's statements and arguments are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept things that the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answers. My comments, rulings, questions, and instructions to you are also not evidence. It's my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If for some reason you believe I have an opinion as to how you should decide this case, you should pay no attention to that and totally disregard that, because you are the only judges of the facts, and you alone will be the ones to decide this case based on the evidence. Now, at times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Base your decision only on the evidence that I let in and nothing else. And your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, a person, or an event. To repeat once more, you must decide this case based only on the evidence that was admitted during this trial. Now, ladies and gentlemen, facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you were to go into the jury room and look out the window and you saw that it was pouring rain by looking out the window, that would be direct evidence of the fact that it was raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you were to have come in one day and the weather forecast was for rain, and there were dark clouds when you arrived here at Frank Murphy, and you heard thunder while you were in the jury room, and then you came out and sat in this room, which has no windows in it, and you saw someone walk in the front door of the courthouse, to the courtroom, and they were shaking out a wet umbrella. That would be circumstantial evidence of the fact that it was raining outside. Now, you may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of the crime. In other words, you should consider all of the evidence that you believe. Now, ladies and gentlemen, if you believe that a witness previously made a statement inconsistent with their testimony in this trial, the only purpose for which that earlier statement can be considered by you is in deciding whether the witness testified truthfully in court. The earlier statement is not evidence about what the witness said as to whether or not that is true. Now, in this particular case, you did hear testimony and evidence that the defendant had been convicted of a crime in the past. You may consider this evidence in deciding whether you believe the defendant was truthful when testifying from the witness stand. You may not use it for any other purpose. A past conviction is not evidence that the defendant committed the alleged offense in this case. Now, ladies and gentlemen, you have also heard during the course of this trial that a lawyer or lawyer's representatives talked to one of the witnesses. There's nothing wrong with this. A lawyer or a lawyer's representative may talk to a witness to find out what that witness knows about the case and what the witness's testimony will be. During the course of the trial, ladies and gentlemen, you heard testimony from 3 expert witnesses: Danielle Keith, Robert Charlton, and Stan Brew. The expert witnesses gave you their opinions as experts. Danielle Keith gave you her testimony as an expert in the area of fingerprint comparison. Robert Charlton gave you expert testimony with regards to the area of firearms and tool mark identification. And Stan Brew gave expert testimony and his opinion in the area of cell phone tower analysis. Experts are allowed to give opinions in court about matters that they're experts on. However, you don't have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and the facts given for their opinion, and whether those facts are true. You should also think about the expert's qualifications and whether the opinions make sense when you think about the other evidence that has been presented in the case. Now, ladies and gentlemen, Robert Williams and Don Diego Adams say that they took part in the crimes that the defendant is charged with committing. Both Mr. Williams and Mr. Adams have already been convicted of crimes arising out of the same alleged criminal incidents. Such witnesses are called accomplices. Now, you have heard that Mr. Williams and Don Diego Adams made agreements with the prosecutor about charges against them in exchange for their testimony in the trial. You've also heard evidence that Mr. Williams and Mr. Adams faced a maximum penalty, possible penalty, of life in prison as a result of those charges. You're to consider this evidence only as it relates to Robert Williams and Don Diego Adams' credibility, and as it may tend to show Robert Williams and or Don Diego Adams' bias or self-interest. Now, you should examine an accomplice's testimony closely and be very careful about accepting it. You may think about whether the accomplice's testimony is supported by other evidence, because then it may be more reliable. However, there's nothing wrong with the prosecutor using an accomplice as a witness. You may convict the defendant based only on an accomplice's testimony if you believe the testimony and it proves the defendant's guilt beyond a reasonable doubt. When you decide whether you believe an accomplice, consider the following. Was the accomplice's testimony falsely slanted to make the defendant seem guilty because of the accomplice's own interests, bias, or for some other reason? Has the accomplice been promised that he will not be prosecuted or promised a lighter sentence or allowed to plead guilty to a less serious charge? If so, could this have influenced his testimony? Does the accomplice have a criminal record? In general, you should consider an accomplice's testimony more cautiously than you would that of an ordinary witness. You should be sure you have examined it closely before you base a conviction on it. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and the evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard testimony from a number of police officers in this case. That testimony is to be judged by the same standards that you would use to evaluate the testimony of any other witness. Now, ladies and gentlemen, as I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You don't have to accept or reject everything a witness said. You're free to believe all, none, or a part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice based on the race, gender, or national origin of the witness. Now, there is no fixed set of rules for judging whether you believe a witness, but it may help you to think about the following questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was there anything else going on that might have distracted the witness? Ask yourself, did the witness seem to have a good memory? And how did the witness look and act while testifying? And by that, I mean, did the witness seem to be making an honest effort to tell you the truth? Or on the other hand, did the witness seem to be evading the questions or arguing with the lawyers? Did the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case gets decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, you should ask yourself, does the witness have any special reason to tell you the truth? Or on the other hand, does the witness have any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence that is presented in the case? Now, sometimes the testimony of different witnesses will not agree, and you must decide which testimony you're going to accept. You should think about whether the disagreement involves something important or not, and whether you think somebody is lying to you or whether they're simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence that's in the case. However, you may conclude that a witness deliberately lied to you about something that's important for your decision-making in this case. If so, you may choose not to accept anything that witness had to say. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and just ignore the rest. Now, ladies and gentlemen, the prosecutor must also prove beyond a reasonable doubt that the crimes of armed robbery and assault with intent to murder occurred on or about March the 5th, 2015, within Wayne County, and that the other crimes alleged occurred between January and May of 2015, also within Wayne County. Now, ladies and gentlemen, when you go in to deliberate, you're going to be provided a verdict form. And I want you to understand that when you go in and deliberate, you have to make a separate decision about each count. And I'm going to explain to you, in count 1, the charge is conspiracy to commit armed robbery. And with regards to that particular charge, and that's the conspiracy that the prosecution claims began in January of 2015 and ended in May of 2015. And with regards to that particular count, you may find the defendant either not guilty or guilty of conspiracy to commit armed robbery. Now, with regards to that particular count, let me go over again with you what the elements of that particular charge are. What does the prosecutor have to prove, and prove beyond a reasonable doubt? And I want you to note that count 1 deals with conspiracy to commit armed robbery. Count 2, which I'll talk about in a couple of minutes, is the crime of armed robbery. The difference essentially between the two is that the conspiracy involves a criminal agreement between 2 or more people. All right? So let me start with the elements of the offense of conspiracy to commit armed robbery. To prove this charge, the prosecutor must prove the following beyond a reasonable doubt. First, that the defendant and someone else knowingly agreed to commit armed robbery. Second, that the defendant specifically intended to commit or help commit that crime. And third, that the agreement took place or continued during a period from January 2015 through May of 2015. So the conspiracy is the criminal agreement, but it's not just an agreement to do anything. It's, in this case, an agreement to commit armed robbery. So what is armed robbery? I'm going to go over that, what the elements were. To commit, for the prosecutor to prove the crime of armed robbery or conspiracy to commit armed robbery, the prosecutor must prove the following beyond a reasonable doubt. First, that the defendant used force or violence against someone. Second, that the defendant did so while he was in the course of committing a larceny. And a larceny is the taking and moving of somebody else's property or money with the intent to keep it away from that person permanently. And the law defines in the course of committing a larceny to include acts that occur in an attempt to commit a larceny, or during the commission of a larceny, or in flight or attempted flight after the commission of a larceny, or an attempt to retain possession of property or money. Third, that someone, the victim, was present while the defendant was in the course of committing the larceny. And fourth, that in the course of committing the larceny, the defendant possessed a weapon that was designed to be dangerous and capable of causing death or serious injury. Now, as I indicated to you, ladies and gentlemen, a conspiracy is an agreement. And an agreement for a criminal conspiracy is the coming together or meeting of the minds of 2 or more people, each person intending and expressing the same purpose. It's not necessary for the people involved to have made a formal agreement to commit the crime or to have written down how they were going to commit it. In deciding whether there was an agreement to commit a crime, you should think about how the members of the alleged conspiracy acted and what they said, as well as all of the other evidence. To find the defendant guilty of conspiracy, you must be satisfied beyond a reasonable doubt that there was an agreement to commit armed robbery. However, you may infer that there was an agreement from the circumstances, such as how the members of the alleged conspiracy acted. If there was a conspiracy, ladies and gentlemen, you must decide whether the defendant was a member of it. You may only consider what the defendant did and said during the time that the conspiracy took place. Finding that the defendant was merely with other people who were members of the conspiracy is not enough by itself to prove that the defendant was also a member. In addition, the fact that a person did an act that furthered the purpose of an alleged conspiracy is not enough by itself to prove that the person was a member of the conspiracy. It's not necessary for all the members to know each other or to know all the details of how the crime will be committed, but it must be shown beyond a reasonable doubt that the defendant agreed to commit the crime and intended to commit or help commit it. The defendant is not responsible for the acts of other members of the conspiracy unless those acts are part of the agreement or further the purposes of the agreement. If the defendant agreed to commit a completely different crime, then he's not guilty of a conspiracy to commit armed robbery. So, ladies and gentlemen, as I indicated to you with regards to count 1, the conspiracy to commit armed robbery, which is between January and May of 2015, you may find the defendant not guilty or guilty of conspiracy to commit armed robbery. In count 2, the charge of armed robbery relates to the specific events of March the 5th, 2015, with the claim that Terrence Berg was the victim of an armed robbery. With regards to that particular event, you may find the defendant either not guilty or guilty of armed robbery. The third count, ladies and gentlemen, is the charge of assault with intent to murder. And with regards to that particular charge, you will have to choose and select one of 3 options. You may find the defendant not guilty, or you may find the defendant guilty of assault with intent to murder, or you may find the defendant guilty of the lesser offense of assault with intent to do great bodily harm. To prove the charge of assault with intent to murder, the prosecutor must prove beyond a reasonable doubt that first the defendant tried to physically injure another person, in this case, Terrence Berg. Second, that when the defendant committed the assault, he had the ability to cause an injury, or at least believed he had that ability. And third, that the defendant intended to kill the person he assaulted, and the circumstances did not legally excuse or reduce the crime. Now, ladies and gentlemen, I will provide you, when I send in the final jury instruction book, you'll each get a copy of the elements of assault with intent to do great bodily harm. And let me tell you that the difference between assault with intent to murder and assault with intent to do great bodily harm is with regards to the third element. Assault with intent to murder requires that there be an intent to kill. With regards to assault with intent to do great bodily harm, there has to be an intent to do great bodily harm. For assault with intent to do great bodily harm, less than murder, the first 2 elements are exactly the same as the elements for assault with intent to murder. That is, that the defendant tried to physically injure another person, and second, that at the time of the assault, the defendant had the ability to cause an injury, or at least believed he had the ability. For assault with intent to do great bodily harm, the third element that the prosecutor must prove beyond a reasonable doubt is that the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was an injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. Now, ladies and gentlemen, fourth count for you to consider in this case is the charge of being a felon in possession of a firearm. With regards to that particular offense, you may find the defendant either not guilty or guilty as charged of being a felon in possession of a firearm. To prove this charge, the prosecutor must prove the following beyond a reasonable doubt. First, that the defendant possessed or used a firearm in this state. Second, that the defendant had been convicted of a specified felony. And third, that the defendant's right to possess or use a firearm had not been restored as of January 2000 through May of 2015 here in the state of Michigan. The final charge, ladies and gentlemen, the fifth charge for you to consider is the charge of what's known as felony firearm. And that is the crime of possessing a firearm during the commission or attempted commission of a felony. Now, it sounds a lot like felon in possession in terms of label, but they are two very different concepts. Felon in possession charge deals with the notion of someone being convicted previously of a felony, possessing or having a firearm in their possession when their rights to have that had not been restored. Felony firearm doesn't matter what someone's previous conviction was. Felony firearm punishes the possession or use of a firearm during the commission of a felony. So in this particular case, the prosecutor must prove the following beyond a reasonable doubt. First, that the defendant committed the crimes of either conspiracy to commit armed robbery and or armed robbery and or assault with intent to murder and or assault with intent to do great bodily harm and or being a felon in possession of a firearm, which I've already defined for you. It's not necessary, however, that the defendant be convicted of those crimes. Second, that at the time that the defendant committed those crimes, he knowingly carried or possessed a firearm. Doesn't matter whether or not the gun was loaded. A firearm includes any weapon from which a dangerous object can be shot or propelled by the use of explosives, gas, or air, and under Michigan law, a pistol is considered a firearm. So with regards to the charge of felony firearm, you may find the defendant either not guilty or guilty as charged of felony firearm. Now, ladies and gentlemen, one of the issues in this case is the identification of the defendant as the one who committed the crime. The prosecutor must prove beyond a reasonable doubt that the crime was committed and that the defendant was the person who committed it. In deciding how dependable an identification is, think about such things as how long the witness was watching, whether the witness had seen or known the offender before, how far away the witness was, and whether the area was well lighted, and the witness's state of mind at the time. Also, think about the circumstances at the time of the identification, such as how much time had passed since the crime, how sure the witness was about the identification, and the witness's state of mind during the identification. You may also consider any times that the witness failed to identify the defendant, or made an identification or gave a description that didn't agree with the identification of the defendant during the trial. You should examine the witness's identification testimony carefully. You may consider whether other evidence supports the identification, because then it may be more reliable. However, you may use the identification testimony alone to convict the defendant, as long as you believe the testimony, and you find that it proves beyond a reasonable doubt that the defendant was the person who committed the crime. When you go to the jury room, ladies and gentlemen, you'll be provided with a written copy of my final instructions. You should first choose a foreperson, and the foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. Please remember that a verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you'll discuss the case amongst yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual and considered judgment of each juror. Now, it's your duty as jurors to talk to each other and make every reasonable effort to reach an agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and don't hesitate to change your mind if you decide that you were wrong. Try your best to work out your differences. However, although you should try to reach an agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalty shouldn't influence your decision. It's my duty as the judge to fix the penalty within the limits provided by law. When you go to the jury room to deliberate, you may take your notebooks with you, as well as the instructions that I will be giving. If you want to look at any of the exhibits in this particular case, please write out a note and knock on the door and wait for my deputy to come and take it from you. And we will arrange to send in almost all of the exhibits. I do not send firearms into the jury room. If you need to look at it or want to look at it, we'll bring you out and you can view it here in the open courtroom. If you want to communicate with me while you're in the jury room, please write out a note, knock on the door, and wait for my deputy to come and take that note from you. It's not proper for you to talk directly to any of the parties in this particular case, those who are involved. And as you discuss the case, don't let anyone, even me, know what's the numerical status of your vote. In other words, don't send out a note saying, well, Judge, on this count we're 6 and 6, or we're 9 and 3, or whatever. Until you return with a unanimous verdict, do not reveal the numerical status of your deliberations to anyone who is outside of the jury room. Let me see the attorneys, please. All right, members of the jury, as we know, we have 13 who are here. One of you will be selected as an alternate in this particular case. And if your name is drawn and you are the alternate, I want you to do two things for me. I want you to provide my deputy with a contact phone number where we can reach you tomorrow morning at 9 o'clock in the event that you have to be brought here. And the second thing is I do not want you to talk to anybody about the case. You are still considered technically a part of the jury, and I have not discharged you from your service. And the reason we need you to do that doesn't happen a whole lot, but I can tell you several months ago we had an incident where a jury went out to deliberate. They didn't reach a verdict that day. They needed to come back the next day to deliberate. And what happened was overnight, one of the jurors had a spouse that had a serious medical emergency that arose, and that juror couldn't come back. And so rather than having to try the case all over again, we were able to bring in the alternate, and the jury deliberations continued. So I need your cooperation in that regard. We will hold on to your 3-ring binder. We will keep it separate in the event that we need to bring that. So for our alternate, who will be excused for the rest of the day at this particular time. I know on behalf of prosecution and the defense, and certainly on behalf of myself, I want to thank whoever is the alternate for the yeoman service that they have done, because all of you have been spectacular, I think, in your diligence and attention throughout the trial. So at this point, our alternate will be?
Jury in seat number 3.
All right.